Thank you very much, and welcome to the leap year edition of Workers' Comp 202. You won't have this again for another 4 years, my friends. And by the way, did you know that leap year is every 4 years? It is always a presidential election year in the US, and it does not fall on century years. 1800, 1900? No. 2000, yes. Because 2000 is divisible by 400. That's a lot of information on leap years, but I think you're all set for the next one. So happy February 29th. The Advocate for Injured Workers, well, by way of introduction, that's me. I am the manager of an office known as the Office of the Advocate for Injured Workers. We're a group of people who helps workers with the more difficult and complex claims. My civil service title is actually Ombudsman. An ombuds is a role that you will see at certain types of organizations such as financial services corporations or hospitals or insurance companies. We're the person inside who is supposed to help the customers, the clients, or in our case, the workers, navigate the system. We care about the health and sanctity of the system. I'm the Advocate for Injured Workers. We also have an advocate for business who also does webinars similar to the ones I do. But back to my office, we work on fatality claims. We also work directly with the 9/11 community. And I'd like to show you, if you don't, for a moment, our website with some information on World Trade Center claims and not necessarily claims, but this is information for people who were impacted by the events of September 11 and thereafter. So, starting from the left, you see World Trade Center Health Program. Federal government is paying for clinics to monitor the health of World Trade Center responders and survivors of the attacks. I would encourage you to check that out and get enrolled with those clinics. In the center, you can see that there is a fund known as the September 11 Victim Compensation Fund that is operated by the Federal Department of Justice, and there is compensation available to people who suffered due to the attacks or the aftermath. And finally, there is a World Trade Center Volunteer Fund. This is something my agency, the Comp Board, that we do here because, yes, everyone who was impacted by the attacks who was at work or the responders who came afterwards, those are workers' comp claims, but World Trade Center is the only time in New York State history where volunteers can also claim a World Trade Center, a workers' comp type benefit. Okay, so that's a little rundown on me and my office. Let's go now to, let's talk about our workplaces. Let's talk about what we can do to prevent an incident from ever occurring. This is the moment where I'm sure everyone on this webinar is in agreement. We need to prevent accidents and incidents to the extent that we can. So here's an idea. Why don't you form yourself a labor management safety committee? We have some ideas on screen for how you might want to formulate that committee. But the point here is let's talk to each other. Let's review the workplace. Let's review the spots where accidents are happening or could happen, and let's prevent them. Let's mitigate them. Let's change what we're doing, my friends. Let's review our equipment. Let's review our procedures. Did we document our procedures? Do we know that we're teaching people how to operate and work in the safest possible way? Well, why don't you form yourself a labor management safety committee and review these topics because the injury or life you save could be your own. Also, this agency, the Workers' Comp Board, we have education for you. We are going to show you the page on our website where we have, right here, the publications that we maintain. All these publications here are directed toward workers. And if you continue to page down that page, you'll see what else we have. Look at that. We have publications for employers. We also have our medical treatment guidelines right there. And then we have these other important documents and publications. So we encourage you to come to our website, wcb.ny.gov. And if you go to the bottom of the website in a big green bar, you'll see publications. Click it and enjoy our publications. Here's another tip for workers. We have something called eCase. eCase is what we call the electronic folder where all your claim documents reside. Would you like to see what everyone else sees? Well, it's pretty simple. Register for eCase, and you can. Okay, this is the same thing that the insurance companies see, that the attorneys see, that we see. So if you're a worker, just come, register for eCase. You'll get access to your claim folder. I strongly recommend you do this. And this is what you have to complete. It's going to take you, what, a hot 2-3 minutes? Really recommend you do this one. Now, along these lines, this is some setup, okay, for advocates and workers, so you can be involved in your case and your claim, which you really ought to be. There is an element that you need to know called privacy. The workers' comp law has its own privacy provisions. So yes, we're all familiar with HIPAA and those provisions. Well, HIPAA does not prevail in workers' comp situations. We have our own conditions in our own law. So that means the board can only speak about the details in a claim to parties of interest. Who are the parties of interest? Well, they're right there on screen. The claimant, that's the injured worker, and the worker's attorneys, the employer, the insurer, the attorneys for those parties, and the providers of healthcare can also be parties of interest. If the worker wishes to grant someone else access to claim details, then the worker is going to have to complete this form known as the 110A form. We call it the 110A form because privacy is contained in section 110A of the comp law. So workers, if you complete this form, send it in to us. You need to send us the paper, by the way. Then we can grant someone else access and we can discuss your claim with someone else. Someone's asking, who is speaking now? Yeah, that is not Adam speaking right now. This is actually the advocate for injured workers speaking, your ombudsman. So good morning to our friend AS. He's a frequent guest of ours, and we appreciate everyone who tunes in with us. Okay, now we're going to start to get into the details. Indemnity benefits. Remember, there are two benefits. There's the indemnity benefit. There's the medical benefit. We're going to speak for a long time today about the indemnity benefit. That's your lost wage benefit. So let's look at what's called a controversy. When a claim is disputed, the technical term for a dispute of a claim is a controversy. We say that the claim has been controverted. Okay? When a claim is controverted, no benefits are going to be paid until it's resolved. So that means we have a claim, it's filed, the insurance carrier, the insurance payer is formally controverting. They're going to file something with us called a FROI or a SHROI, and they're going to indicate we are controverting this claim for these reasons. There is a list of reasons they have to choose from, and they have to choose the particular reasons that pertain. They can't just choose all of them. And then it's going to be reviewed in a hearing process. All right, so now we have a controverted claim. It's been controverted. That means that the board has to resolve the controversy. We are probably going to be resolving that in 90 days. It's what is informally known as the rocket docket. I say probably because there are a few instances that don't go into the expedited process, such as an occupational disease. And the reason they don't is because they're more complex. They probably can't reasonably be resolved in 90 days. But most things can be. So the point of this discussion is, number one, if the claim is controverted, the insurance payer is not providing benefits. They don't have to, and they tend not to. So they're not paying the worker, they're not paying the doctors or whoever is doing treatment. But the workers at least can to receive some income. If they are unable to work, they can file the claim for disability benefits. Now, disability benefits are provided for injuries, illnesses that happen off the job. But since this is in dispute right now, no one is sure that it's an on-the-job incident, so you file the disability claim. So you can at least get some income. Right now, we're talking $170 a week. That's the present disability benefit. You know, there's nothing saying that that law can't change in the future, but right now it's $170 per week, and we are showing you the disability claim form right now. So if you're a worker and your claim's been disputed, you can go ahead and file that disability form. If you get the benefit, if your claim does not get established, then you just keep it. If your claim does get established, don't worry. You're not going to have to do anything. The disability insurer and the comp insurer, they might be the same insurance company, but they might be different ones. And if they are different, don't worry about it. They will talk to each other. They will exchange funds. They are very good at this process. All right, another topic within the indemnity benefit world. CCP. CCP stands for Carrier to Continue Payments. This is a very helpful thing for an injured worker because what it means is a judge has directed an insurance payer to continue paying this sum of money every week unless a judge changes it. Okay? It can't be changed by the insurance company. It can't, of its own volition, it can't be changed unilaterally. You're going to have to come back and a judge is going to have to change it if it's eligible for change. That's why this is good for workers, because it means you can depend on this payment. So if you see a CCP, if you're a worker, you're going to continue to get that amount unless it's changed. Indemnity benefits, degree of disability. Okay, this is a topic we're going to spend a few minutes and a few slides on because it is that important. Every comp claim has two elements, a notice and a medical. Right? You need to know that something happened. That's the notice. And since we are a system that deals with injuries and illnesses, we're going to need something from a medical provider discussing what that injury or illness is. Now, there's going to be a lost wage benefit potentially. There's an equation that we use to create the lost wage benefit. And one of the terms in that equation is the degree of disability, or how disabled is our worker. The degree of disability is going to be set by the treating provider. There could be an IME in the future, and an IME might come up with one too, but it's going to start with the treating provider, and it's going to be expressed as a percentage. Now, the percentages are going to range from 0 to 100. 0% disabled, you're healthy. Yay. 100% disabled, you can't work. You're completely disabled, 100% disabled. Now, on screen, we are showing you the most common percentages used. 25, 50, 75. Now, on the left side, as you look at it, you see those terms there? In the olden days that some of us still remember, the doctors and the judges would use mild, moderate, and marked. So we're just showing you marked equals 75, moderate 50, moderate halfway, 50, mild is 25, okay? So we're showing you that. Here's how it now comes into play. You have a benefit rate. Remember we talked the last session, or you know already, average weekly wage, 2/3 of that is the maximum benefit, okay? So the average weekly wage was 900. 2/3 of that is 600, 300, 600, 900. Okay, 600 is the benefit you would get at total 100%. Let's say you're 50% disabled. You're getting half 600. It's $300. Okay, so you see we take the benefit rate, and then your degree of disability is now what percentage of that rate are you getting? Total, you're getting 100% of it. Then you could see down the line 75, 50, 25. There you go. And of course, the maximum benefit you're going to get is always capped on your date of incident. So whatever your injury date is, that maximum that was in effect for that date, that's your maximum for the rest of your claim. So no, there is no cost of living adjustment. Now, a word from Matt.
Hello, everyone. You'll see a scenario on your screen. Joe and I want to get your opinion right now based on what we were just discussing on the degree of disability. I'm going to open up a poll right now. You should see it on your screens. We just want to get your opinion here. No right or wrong answer. So we have Susan. Susan was 100% temporarily disabled, and she's been receiving $1,000 a week for the last 3 months. Susan's doctor recently said that she is healed to the point where she is now 50% disabled. Susan has never had a workers' compensation hearing, so true or false, because of her new disability percentage, Susan's benefit rate could now decrease from $1,000 a week to $500 a week. Again, just put your opinion in the poll here, true or false. Joe and I are not grading you on this. We just want to see what you guys think. We do have some answers coming in, Joe.
Let's give them a moment.
Yeah, it's looking right now. It looks like the majority are saying true, that the degree of disability could decrease. We have some saying false. Right, we have answers coming in both the chat and the poll, so that's good. But if you want, just put your answer in the poll so we can get a little more accurate reading here. But right now, it does look like the majority of folks are saying true. Joe, what do you think?
Well, it is possible, yes, that Susan's benefit rate could decrease to $500 a week. And we say it's possible because what we're really saying is the payer is within its legal rights to reduce to $500 a week. So let's walk through this for just a moment. Susan is receiving 1,000 a week at 100% disability. Okay. Doctor says she's now 50%. So remember, your degree of disability is the percentage of the benefit that you can expect to receive. So 50% of 1,000 is 500. You know, we didn't try and fool you on the math there. We also made sure to say in the third bullet, she's never had a hearing. If she's never had a hearing, that means she can't possibly have a CCP order, carrier continue payments. So that means that the insurance payer can, of its own volition, change that benefit amount. This next one is devoted to our friends in the medical community. We're now going to talk about how you report the degree of disability. So you're a medical provider. Thank you very much. You're indispensable to the system and to the health of injured workers. You're going to be filing a CMS 1500 form, the universal billing form. That's going to have your procedure codes and your charges on it. Yes, we did go to that a year or two ago. We did make that leap. Some of us were thrilled to be able to tell you we were going to do that. But you do need to file a report. You do need to file a little bit of a report in the comp system because we need to know 3 bits of information that are especially important when someone is temporary. Those bits of information are work status. Is your patient working? Yes or no? Causality. Is the condition that you're treating the cause of the disability that might be keeping the worker off the job? And then finally, degree of disability. How disabled is this person? The formal term for that is temporary impairment percentage. Okay? As you've seen, we need that degree of disability to do the equation that yields the benefit. If we don't have that, your patient might not be receiving the lost wage benefit. That's why it's that important. That's why we created the medical narrative report template. So you can handle submitting the CMS 1500, great. But you're going to need some place to put the answers to those 3 questions that you see at the bottom there. Work status, causal relationship, temporary impairment. We made you a template. We made this for you so that you can complete these boxes and then attach it to the CMS and you're done. File it. If you don't want to use that, if you want to send your treatment notes and you wish to answer these questions in your treatment notes, that's great. Go on ahead. I'm just saying, would you please put these 3 questions in the template of your treatment notes so that you're sure to answer them? Okay? It's really that simple. That's really all I'm trying to convey here, but it is really that important because sometimes people don't get their benefit because there's no degree of disability filed. We have a question coming in here. Who and when is the degree of disability determined? Okay, the treating provider is going to indicate degree of disability. Remember, we're in the temporary world here. Once we get to the permanent world, we don't need a degree of disability anymore. It's been established. That's why it's permanent. Okay, PPD, permanent. You have a 50% disability. We don't need that percentage anymore because you've already been classified permanently. This is in the temporary world. Treating providers are going to be expressing this degree of disability. Now, I just mentioned permanency and classification. This is what we're talking about. As a claim proceeds through its life cycle, all the claims begin as temporary. Then we're going to come to a point where the worker has either healed 100%. And Adam, if you're 100% healed, what would your degree of disability be?
0.
0, exactly. We didn't rehearse that, by the way. Okay, so 0. Or, I'm sorry to say, you could come to the point where you're not fully healed. You've arrived at maximum medical improvement, otherwise known as MMI. And a doctor has said, Pam, I'm terribly sorry to tell you that you are 50% disabled permanently. Okay, so we're talking about permanent partial disability now, and I'm going to show you here, permanent partial disability is possible, and it is determined, well, you're going to get a set number of weeks of benefits. That's on the right-hand side of your column, and on the, or your table, and the left column is now telling you what gradient we use to get that. LWEC. LWEC stands for loss of wage earning capacity. We should probably put that on the slide. Next time we do this, you'll see LWEC, loss of wage earning capacity. We'll have it on the slide for you. So what this means is it is a formula that is set that all of our judges know how to do. All of the attorneys who practice in the system know how to do it. We don't review how the formula works in this session because, frankly, it's too complex, okay? We could spend a whole hour just on that. All you need to know is if you have a loss of wage earning capacity between 96 and 99%, that's going to get you 525 weeks of benefits. So your range of benefits is between 225 and 525. That works out to between 4 and 10 years. Okay, so the minimum, if you lost 1 to 15% of your ability to earn, that's going to get you 4 years of benefits, all the way up to the top there will get you 10 weeks. And then your percentages are mapped over to the number of weeks. That's what we use. It's set in law. The other thing that you should know is actually our very next slide. What happens if you're a worker and you're getting these benefits and your health gets worse? Well, this is a classic workers' comp 202 concept. This is what you workers need to know. You're going along getting your benefits and you're just getting sicker, or your health is just deteriorating and the doctors are noticing it. You can come back and pursue what's known as the change in condition, as in your condition has changed for the worse. Therefore, you might be looking to demonstrate that you now qualify for a permanent total disability. There's permanent partial, there's permanent total. Permanent total means you're going to get the maximum rate you can receive for the rest of your life. There is also another benefit that gets you the maximum rate you can receive for the rest of your life, known as total industrial disability. That's the second bullet on screen. That is a vastly underused benefit. Last year, 35 people applied for total industrial disability. 35 people. We touched 250,000 claims in total. 35 of them applied for total industrial disability. That's why I highlight it at these webinars. Total industrial disability means you don't have to have 100% loss of wage earning capacity to be eligible. Total industrial disability takes into account other factors, such as your educational level, your facility with the English language. How old are you? Are you receiving some sort of other disability, like Social Security disability? You can point that out. You're allowed. And, what are the real chances and opportunities you as a worker have to pick up a different career? That's why it's total industrial disability. So if you're on permanent partial, you have a high degree of loss of wage earning capacity. You could do this. Someone's asking, what's the difference between that and LWEC? You can make a separate application for total industrial disability. You can point to factors. It is a separate thing. So yes, some factors go into LWEC, but some don't. Okay. I would suggest that you consult with an attorney if you want to pursue permanent total change in classification, or if you want to pursue total industrial disability. I suggest you consult with an attorney because you really would benefit from legal expertise at these apps. Here's a much simpler concept. Here's some best practices if you're receiving indemnity. Number one, would you please consider using direct deposit? I can't stress this one enough. If you can have a bank account, would you please consider direct deposit? I have no idea why you would want a paper check in the year 2024. In the leap year of 2024, why would you want a paper check? If you can get a bank account, would you please do this? Some of us fought really hard to get you this mandatory option. Number two, if you're getting paid in cash, that's fine, but I'm going to encourage you to keep some records. I'm going to encourage you to keep some records because if you're getting paid in cash, you might need to demonstrate your average weekly wage at some point, might you not? Therefore, if you have contemporaneous records, you might be more believable than somebody who doesn't. So, why don't you get a notebook or open a file on your computer or your phone or your tablet and just note who paid you, what day, how much, for doing what. It could be very helpful. And finally, this is really important for people who work in cities or on remote locations, particularly in construction. Please pay attention to the address of where you're working. Let's say you got hurt. Let's say you're working somewhere in Midtown Manhattan and you're a day laborer, you got picked up, you got brought to a place, you got hurt. There's a huge difference in filing a C3 that says, I got hurt at 777 East 39th Street versus I got hurt in Midtown. Okay? Midtown doesn't help anybody. But if you know the address, there is the possibility the various insurance companies will fight about who's responsible. That happens all the time on construction sites. You have contractors, you have subcontractors. If we know the address, we'll pull the building permit. That tells us everything we need to know. You will save months of hearing time. All right, big topic here. Labor market attachment. We're going to spend the next 3 or 4 slides on this one. So here we go. Remember I was talking about workers who are temporarily disabled as opposed to permanently disabled? Okay. This concept applies to workers who are in the temporary world who are less than 100% disabled. There is this concept that says workers in those conditions, temporary, less than 100% disabled, what we call temp partial, temporarily partially disabled. If you're temp partial, you could be asked to look for employment within your restrictions in order to continue receiving the lost wage benefit. This is not spelled out per se in the comp law, but it does come from what's called case law. As in, workers' comp claims get appealed, they get reviewed, they go through the board, they might go to the appellate court. That's case law. So if you're interested, you can read what's known as the American Axle decision. An insurer can raise this issue at a hearing, and they do. The judge could ask the worker to demonstrate labor market attachment, and they do. Labor market attachment means, are you looking for a job within the scope of your restrictions? Well, if someone asks you to do this, workers, like a judge, if a judge asks you to demonstrate your labor market attachment, you have to do it. How do you do it? Well, the first thing to consider is, what do you have to demonstrate? Well, look on screen there. See it in green? You have to demonstrate a timely, diligent, and persistent work search. So the type of the work search is known: timely, diligent, and persistent. We just can't tell you the amount. We just can't tell you the numbers and the dates, all the objective stuff. This is a completely subjective standard that the judges are going to have to make a decision whether your work search is timely, diligent, and persistent. So, how do you demonstrate this? Here's how. Someone's asking, who decides what your restrictions are to demonstrate this? Your restrictions are well known because you're 50% disabled, 75% disabled. So those are your restrictions. And if the doctor has listed specific restrictions, like you can't lift more than 10 pounds, that would be taken into account too. The restrictions are coming out of your medical file. So how do you demonstrate it? Okay, so number one, workers, if you're asked to do this, you need to do this or your benefits could be suspended. How do you do it? Okay, I'm going to show you two different primary avenues. This first avenue, you can use the State Department of Labor Reemployment Services. State Department of Labor has someone, or they have staff, who can help you find a job. Take advantage of them. You could go to their one-stop career centers, where if you need to use computers, let's say, they have them there. You can go to libraries, of course. People love to do that. You can go to the Department of Labor one-stop career centers as well. They also have seminars and counseling on trying to find a position. Yes, you can take advantage of that. You can do vocational rehab through Access VR. If you are old school, you used to call that VESID, but you can use vocational rehab through Access VR. You can also talk to our agency, Voc Rehab counselors. Yes, the board. And then my employer, we have Voc Rehab counselors. We can hook you up with them. Or you can go to college or some form of higher education or training. You know, so long as it's accredited, yes, you can do that. Maybe you're a high school graduate and this is your opportunity to go to college and learn a whole different career and a whole different thing. This is your chance. Now, you're going to have to demonstrate it, which means you need to make a record. On screen, we are showing you Form C-258. We have a lot of forms at the board, but this is a pretty important one. This is the claimant's record of job search efforts and contacts. So you can document these things that I've just explained to you on that form. You can do it freestyle on a piece of paper and send that in too, but the form makes it really easy, and you certainly can submit multiple copies of this. You know, if you're going every week, you want to submit 6 weeks worth, 6 weeks aren't going to fit on one form, send in multiple copies. please document, document, document. Can't stress that enough. Include a resume in your board filings. Why would you want to include that? Because it shows us that you're serious. It shows us what you're using to get the job. You're essentially demonstrating your labor market attachment. So I don't know, I would think a resume indicates you're serious about this. Now, there's another route you can pursue, and you can do both. Please don't think you can't. You can do everything I'm saying. The independent work search. This is when you're actually applying for jobs directly. Let's say you went to the One Stop Career Center, Department of Labor, and you sat there with a voc rehab counselor and you came up with 20 jobs that you applied to each of the 20 jobs. You're going to document all of this. Sitting with the counselor, applying for jobs, and then you're going to list your 20 jobs that you applied for, and you're going to use, you could use a piece of paper if you want, or you can use this form, the 258.1. Okay? You're going to list in detail everything that demonstrates you actually looked for a job. Who did you contact? What was their name, their address, their phone, if you used a phone? Did you do it online? Well, if you did, you're going to indicate those items. The date, the position, the site name you used. You go to Indeed, you go to Monster. Did you go directly to bigcorporation.com and apply through their specific thing? Tell us. If you got an email confirmation, include it. Is there a job reference number? Include it. Just fill in the form. Just demonstrate that you're doing this and taking it seriously. All right. That is what we wish to say about labor market attachment. It is a topic of great interest to the public. I would just encourage you, generally speaking, take it seriously and document everything. Submit your documents regularly, okay? Don't stack them up for the end. Just keep them coming in. Now, a new topic. There are penalties for late payment possible. In the case of ongoing benefits, the benefits have to be paid within 18 days of incident or 10 days from notice, whichever is later. Okay, so you got hurt on February 1st. You told your employer, okay, you're 100% disabled. No one's arguing about it. The first lost wage benefit check should arrive by February 19, assuming you got your medical in on time, assuming your doctor filed it on time, or 10 days from notice, whichever is later. If you told your employer on February 2, 10 days would be the 12th. That's why the 19th. The benefits, well, okay, let's talk now about if there's a decision. Workers, there is a date here you should be tracking. Let's say you have a hearing on February 1st. The judge awards you benefits. It's going to have a filing date of February 3 or 2 or 4. It's going to have a filing date on the lower right-hand side of the page because it does take us a day or two to actually formally prepare the decision. That's called the filing date. The money has to be released within 10 days of that filing date. So if you have a hearing on the 1st, filing date is the 3rd, the money has to be released by the 13th. That's why I'm saying getting direct deposit, because if you're already set up for direct deposit, you should get the money by the 13th. If you're not, then they're going to have to print a check, and the postmark on the check has to be the 13th or sooner. If it's not, tell us, because you could possibly be due a penalty payment. Also, workers, I have to tell you, if you're getting your check every 2 weeks, your check is not late until it's 25 days late. So we do get inquiries from people who are accustomed to getting their check on a Tuesday, and Friday comes and they still don't have their check. And yeah, okay, I'm sorry too you didn't get it on the Tuesday that you're accustomed to. But okay, it's worth it to maybe you want to contact your payer and say, hey, where's my check? That's fine. But it's not going to be late for a penalty until it's 25 days late. That's why I'm so insistent on direct deposit, because we eliminate all those contacts about my late check. Also, payers. Let's say there's an appeal. Let's say the worker prevails on the appeal. You might owe interest on that money that was delayed. You need to do those calculations and send that interest, please. All right. We're deep into it, my friends. We're now into the medical care. So we do have a few medical care concepts. Number one is the medical treatment guidelines. We do have guidelines in New York State for the providers to follow that discuss how to treat 16 different situations. There are 16 individual guidelines. And we are showing you right now the web page that we have that, number one, you could see those bulleted items. You could see what the guidelines are. And number two, we have all this information for our providers about our guidelines. Now, here are some specific things we'd like to tell you. Prior authorization. Sometimes a provider is going to need a prior authorization to do a service. There are two circumstances where prior authorization is going to be required dependably. Number one, does the treatment vary from the medical treatment guidelines? If it does, then the provider is going to file a variance request. The other condition is if the treatment is going to cost more than $1,000. That means the provider is going to file a request for authorization. Okay, these are the two instances that will get you what we call a PAR, a PAR. And a PAR stands for prior authorization request. So what we'd like you to know is that the providers have to make that filing, okay? Workers, you don't do this. Attorneys don't do this. These are medical questions. So therefore, it's natural that a provider would be making the filing. And then there is a review process for these PARs that we are now going to walk you through. There are 3 levels of review. Level 1, the payer gets it first, and an adjuster, or more probably a nurse at the payer, is going to do the initial review, level 1, L1. So let's say that you're looking at the folder, the claim folder, you will see MG2-L1. Now, if it's granted, it'll be L1G for granted. Yay! Or if it's denied, it's going to be L1D for denied. Okay, if it is denied, then it is automatically escalated to a physician now at the payer. And with the physician's much greater training and knowledge and experience, physician might approve something that a nurse didn't approve. Okay, great. So it's going to be MG-L2G for granted. Yay. Or let's say it's denied. Again, so it's a second denial. Okay, now that it's been denied twice, the treating provider has a decision to make. If the treating provider is confident in everything that's already been submitted, the treating provider can ask for the board's medical director's office to review it. That's level 3, L3. However, let's say the treating provider is looking at the denials, and the denials will have reasons for denial. Let's say that there's some information that the doctor didn't originally submit that maybe they could submit. Well, that's where you can redo it. You can redraft it and you can submit it and start the process again with the new info, and that might get you an approval on L1 or L2. Adam, are we going to make this slide deck available for our audience?
We will not have a copy of the slide deck. However, we are recording this webinar and we are going to edit it and put it up on our website and our YouTube page. We will email you when that is available. So just make sure you're signed up for email updates so you know when that is ready for you to view.
Okay.
Thank you.
Okay. Yeah, that's us answering a quick question for somebody who might have to go, who's thanking us. Okay. Now, what happens if...
Slide. Same slide. We're still on.
Yeah, you're cool. What happens if the L2 is not done by a physician? That's a question we got. Or actually, it says doctor, not physician. Okay, well, if I'm not sure myself if the law says it has to be a physician. It just seems like it always is. So, if you have a position review where the L2 is done by someone who's not a physician, you can bring that forward and we'll check it out. I'm sorry, I just don't know off the top of my head if it's mandatory that it's a physician. It seems like it always is. Just want to let you know that there is also a drug formulary, and the same procedure prevails there. Let's say the prescriber wants to use the medication in a way that's not automatically approved under the formulary. Well, same process prevails. If you're a treating provider, there is this other route you can do called the optional pre-approval, the MG1 process. That's an optional pre-approval. That means that the procedure you want to do is already approved under the guidelines, but you can fill in this form and ask for a pre-approval for something that's already approved. I don't know why you would ever do that, but there are providers who do that very frequently. So that is a possibility. I'm just not sure why you would ever do that. And then finally, we can create an order of the chair in some circumstances if an insurer does not do the review. We can do an order of the chair that says, yes, this is payable, go on ahead. We don't do it in every circumstance because there are some medical procedures that you don't want to just automatically approve. They really do require a review. Here's a best practice for medical care. You're a worker, you're showing up for care. Try and bring your board case number with you. Try and bring the insurer's case number as well, and bring the name of the insurer. Your medical office staff will totally love you if you show up with these items. What's the deadline for the doctor to file a level 3 review? I think it's like 8 or 10 days. I think it's 8 or 10 days. It is on our onboard training website, okay? So you can check it out there. We're going to look that up for you because we're really good with knowing where our information is, and we'll get you that in a moment. Adam has been nice enough to put in your chat the URL, the address of our onboard website. I would really recommend that to you if you're in the provider community. I really recommend you check that out because we spend a lot of time putting information there, and we put a lot of information there. We want to see you succeed. We want to see you treat our injured workers. So we're trying. Here now is a best practice for independent medical exams. Because, yes, the insurer can ask the worker to see a provider it is paying to give an opinion on some element of the worker's health or claim. So, that means, number one, there is no doctor-patient relationship here. This doctor, if it's a doctor, and it is almost always a physician, is not going to give you treatment recommendations. They're not going to treat you. They're going to give an opinion to the insurance company about some element of your health or your claim. So workers, you may bring a witness. Yes, you may. Even in the time of COVID, you may. No one can tell you no. You or your witness may record this IME. No one can tell you no. You know those cell phones so many of us have? They have video, they have camera, they have microphones. You can use that. You can record that exam. And the reason is because you are going to get a copy of the report the doctor generates. You should take a look at it. You should make sure that everything that's in that report is by dint of your memory or by reviewing that video actually from that exam. That's why you're taking the video. If there's an impression of, or if there's a finding about, say, your range of motion, you should be able to see a range of motion test on that video. Now, if you have a lawyer, you might want to you definitely want to show the video to your lawyer, A, because the lawyers have opinions as well, but B, because the lawyers might be able to identify a moment in an exam where range of motion was taken where you didn't identify it because you don't do this every day. You don't really know. This is the first time you've had such a thing. The lawyer might be far more experienced. The lawyer will be far more experienced. Now, you can make complaints about IME conduct to my office. Conduct. If the IME says you're 0% disabled and your doctor says 100%, that's not conduct. That's a disagreement that has to be litigated. But conduct, were you treated professionally? Was your exam performed in a professional and medical type facility? Were the findings in the report actually found due to the visit and the exam? You know, that sort of stuff. That's conduct. That you can make a complaint to my office. I will see it. I will triage it. I will probably be referring it to the health provider discipline unit because we do have one of those and we do investigate these complaints. I promise you we do. I just sent one over yesterday, as a matter of fact. Finally, you can claim travel reimbursement to and from one of these exams. You're going to use Form C-257, same way you claim travel reimbursement to medical visits. And given the distances that you're sometimes asked to travel, yeah, you might want to do this. I would just encourage our payers to, if at all possible, try and get our workers to IMEs close to where they live, please. Okay. Breaking news here. Escalating a PAR to level 3 review needs to be completed within the timeframes in the due date column. So the system will tell you. Okay. So what we have found out is when you go to escalate while you're in onboard, due to the particular circumstance of what you're escalating, you're going to have different deadlines possible. But the good news is Onboard will tell you what that deadline is. Let's say in the worst case scenario, you blew the deadline. Okay, it's not that big a deal. You just resubmit. You just start the process again. And you want to just make sure that you have, now that you have another crack at the, another bite at the apple. Now that you have another bite at the apple, you might as well check everything and make sure you've addressed everything that's gotten you denied to this point in your resubmission. Appeals. Okay, we're getting towards the end now, but this is a very big topic. Appeals. It is possible to appeal a judge's decision. Either party can do it, the worker or the payer. You have to do it within 30 days of the filing date. Okay, remember I talked about the filing date? You need to file your appeal within 30 days of that filing date. If you're a worker and you have an attorney, your attorney handles this. Please let your attorney handle this. If your attorney doesn't want to appeal, you two should really talk about that. You should really hear the attorney out on that question. If you're a worker and you don't have an attorney and you appeal it yourself, go on ahead, appeal it. If you miss the 30 days, it is possible we might take your appeal in the interest of justice because you're not an attorney. Your appeal is going to be decided by a panel of 3 board members. The name of our agency is the Workers' Compensation Board. There's also a board of 13 people known as the Workers' Compensation Board. These 13 folks are nominated by the governor of the state of New York and approved by the Senate of the state of New York. And they come on our board for a term for a number of years. Their primary obligation or responsibility is reviewing appeals. So a panel of 3 board members is going to review your appeal. If benefits are found payable, then they have to be paid now. Now remember, we talked about a claim being controverted or disputed, no benefits were being paid. If the worker won, the insurance company still doesn't have to pay benefits if it appeals. It gets an automatic stay on payments for appeal, but now if the panel finds in your favor, workers, they have to pay. However, it is possible to appeal again. The next appeal can go to the full board of 13 members. However, remember I said 3 members looked at your first one? If their decision was split 2-1, it's definitely going to the full board. Now it's a mandatory full board review. If they were unanimous, though, 3-0, but you still want to appeal it to the full board, you may. But it's just that now the full board decides whether it wants to hear it or not. That's called discretionary, and sometimes they do hear it. Sometimes they don't. From there, the next stop is the New York State Supreme Court, Appellate Division, 3rd Department. Now, technically, you can skip the full board and you can go right to the Appellate Division. It's unusual to do that because our appeals are free. And you have to pay some money to go if you go to the Appellate Division. But you can skip the full board if you wish. But either way, the next step would be the Appellate Division. No, please. Thank you. The Appellate Division is going to now review your appeal. Just want you to note, if you're in the Appellate Division, you have left the board. There is nothing the board can do now until the Appellate Division decision comes down. And when it comes down, our board of 13 votes on whether they're going to accept it or accept a decision, or whether we think we want to appeal it even higher, because that is possible as well. So to review the chain of events again per request, judge's decision, then it can be appealed to a panel of 3 board members. This is all on screen, by the way. The 3 board members, they're going to decide if they all agree. Then if you want to appeal it again, you can appeal it to the full board, but they don't have to take it if they don't want to. If the 3 panel members split, it's mandatory. It has to go to the full board. And then after the full board, you can leave our agency and go to the appellate division, which is now a court. We don't operate courts, people. You're now in a court and a part of the New York State Supreme Court. This is one of our last major topics, but it's a good one. What's a settlement? What is a settlement? Why am I asking that question? Well, it's because people use the term settlement very casually. They seem to think that at some point, the insurance company owes them a large lump sum payment. And that's not correct. A settlement is one and one thing only in this system. It is a Section 32 waiver agreement. It is a special contract and agreement struck between the worker and the payer that says, in exchange for a payment today, or a schedule of payments that begin today, the worker is closing the medical part of the claim, or the lost wage part of the claim, or both. Whenever you close workers, you have left the comp system. If you close the entire claim, you have left the system. There's nothing more we can do with you or for you. You can just close the indemnity and keep your medical care open. That's possible. Sometimes people do that. I guess you could technically close the medical and keep the indemnity open. I've never actually seen that, but it is technically possible. You could do that. Just want to make the point, it's forever. So you have left us if that's what you're doing. Remember, the board will review this. The board has to review this. We are going to approve it unless we have to do a review and we have to approve it in order for it to be final. We're going to approve it unless, number one, it's legally unsound. You did it wrong. Or number two, the agreement is unconscionable. Other than that, we don't have a role in this, and we absolutely do not negotiate it. Okay, so sometimes workers come and ask us, can you help me negotiate this? Can you help me get this, that? I'm sorry, we can't, because this is an entirely optional thing. But you might want an attorney to help you. You might want an attorney to help you with your claim. So workers, we can't give you the name of a particular attorney, but here's how you get a comp attorney. Okay, the first way is you can go to the State Bar Association. There's your info. Second way, you can go to the New York State Injured Workers Bar Association. There's your info. You can also retain a licensed representative. That is someone who is technically not licensed to practice all law, but did take an exam given by this agency and has been granted a license to represent injured workers. Or finally, the last bullet, let's say you have a medical only claim. Okay, no lost wages, no lost time, never, never, never. but you do have a claim, you are having trouble with medical care, maybe you got called for a hearing, the subject of your medical care. We have a special program with the Bar Association where they can refer you to some attorney who will do your claim for free. So visit nysba.org, select workers' comp, and they'll get you the name of some attorneys who will represent you for free. Finally, virtual hearings. Let's say you have a hearing. Okay, it's going to be virtual right now, because right now we are still closed to the public. Even when we reopen to the public, you will always have this virtual option. This is a really good thing, because if we didn't have this, we wouldn't have been able to do hearings during the pandemic like the court system. But we were prepared. And we had these virtual hearings that are essentially a teleconference. And we have an app you can use. You can download it from Google or Apple. And you can use this app to join your virtual hearing. You don't have to use the app if you don't wish to. You're going to get a hearing notice, and the hearing notice is going to contain the directions to connect to your hearing. I'm encouraging all workers to attend their own hearings. You can also attend your hearing by telephone if you have to. If you don't want to do the teleconference thing, you can do it by phone. You just need to get to us before hearing day and tell us you're going to go by phone because the judge calls you. The judge calls you. You don't call in. Your lawyer doesn't call you. The judge calls you. Here's our social media presence. We're wrapping up, folks. We're moving to questions. So if you have questions, start typing them now. We are on these various channels. We do comp or agency specific stuff. We do not send dancing kittens to you, as much as we might enjoy it or wish we could. But if you're getting something from us, it is business related. It's important. You also see our YouTube presence there. We have how many zillions of videos out there, Adam?
Sure. 286.
We have 286 different videos. Wow. So, including, there'll be a video of this one and the one that we did 2 months ago and the one we did 2 months ago. They're all there. We actually have a little playlist set up that'll make it a lot easier to find what you're looking for, by the way. Want to encourage you to check that out. Want to encourage you to check out the final one where you can register for notifications of the type that you like. And then I think that we should probably leave this slide up. This is how you contact my office. There's our phone, there's our email. You will be coming into my office and speaking to one of us. We have a good number of reps now. We've expanded to help you out. We also have that email address. You might get an email response within 5 minutes. I might have written your response. So just encouraging you, get in touch with us. We are here. We are really trying to help you. And with all of that, Adam, what do you say we start looking at some questions?
Yeah, sounds good. Again, if you have a question, feel free to type it in the chat box and the right-hand side of your screen. I know we answered a few during the presentation, but we did have a few that came in that we did not get to. So at this point, Joe and I are going to take a quick break to review some of the questions that have already come in, and we will be back with you shortly. Thank you. All right, we are back. So our first question, note that the New York State public employees are not eligible for short-term disability, but could charge leave credits pending controverted claim resolution.
All right, Adam, that's someone being very helpful, talking about if you're a public employee, let's be very precise. If you are a public employee, the government entity is not required to provide short-term disability insurance, the same way a private employer is. However, just want to reiterate, the public employer can choose to provide you with disability insurance. And the most obvious example is that some public employers are providing paid family leave insurance. Paid family leave is provided for under the disability policy, it turns out. That's why this agency is the regulator of PFL. So if you want PFL or short-term disability and you work for a public, you can lobby for it. You can talk to your employer about it. You can try and change the law. That's totally fine.
Yeah, and on that note, I just want to make a quick plug for public employers and PFL. We are going to be hosting a paid family leave webinar for public employers on March 5th. If you go to our website, paidfamilyleave.ny.gov, you'll see that on the webinar section. You can register for that. All right, next question. How long does it take to receive disability benefits once they're applied for?
Short-term, okay, so I'm assuming you're talking about short-term disability. Golly, I think it's within 30 days, I think. It might even be quicker than that. It's either 30 days or quicker. I would encourage you to visit our website and look up short-term disability or even the short-term disability publication. It will specify precisely in there. Sorry, I don't have that right off the top of my head. I do think it's within 30 days though.
Why are indemnity benefits not tied to COLA?
Why are they not tied to COLA, cost of living adjustment? Why is there not an automatic cost of living adjustment in indemnity benefits? Because the law doesn't say that there is one. That's why.
How are multiple injuries calculated in LWEC? Is each injury separately added together, or is hearing loss calculated in addition to the LWEC?
Oh,
Well, these are three separate questions, sorry.
they are. But that's okay because we're going to pull them apart. Multiple injuries, multiple sites. Okay, the formulas account for that. Now remember, you're never going to exceed 100%. But the formula does take into account the possibility that the worker could have injured both an arm and a shoulder and the left leg. So yes, that they are accounted for. However, interesting question here. Hearing loss. Hearing loss, in my opinion, is one of the most overlooked benefits in the system. An awful lot of people suffer a hearing loss due to employment and never claim the hearing loss benefit. So the hearing loss benefit is a separate thing. It does have separate conditions. Like, for example, you have to leave the work environment for 90 days before you can be properly assessed. But if you've lost hearing due to employment, I would encourage you to check that out. You would benefit from an attorney in that instance, and you would have to see hearing specialists. But yeah, please be aware that this does exist, this benefit. All right. We do have a question that talks about a worker being in a wheelchair and maybe some strategy is happening on behalf of the payer. I'm sorry if that is what is happening. If you are in hearings, then everything's going to come in front of the judge. If you don't like what's happening at the hearing, you have to bring it to the judge's attention. Okay? That is the best way I can handle questions such as this one and make it universal for everyone else. If you're in hearings, you don't like what's happening, bring it to the judge's attention. You might have to make a legal argument. Now, we have another question that has a very particular lengthy circumstance. It's so particular that I'm not sure how to even address it with you. I'm talking about someone who seems to be an attorney or a legal rep who has an injured worker in hearings, told benefits would be ending on a certain date. And if they wanted further awards, they'd have to produce evidence of labor market attachment. Well, I can tell right away that there's a detail or two missing from that one. No, if you're presently receiving awards, you're not going to have your awards end without labor market attachment. You're going to be asked to demonstrate to continue. Essentially, this person should probably contact us with a claim number so that we could review something in particular. You know, the specifics of that claim. So that's what I'm going to say about that one. What else do we have here, Adam?
All right, we have a question here. Is there a deadline that a physician can upload a bill?
Yes, well, in this instance, it's easy, Adam, because they're asking about treatment in 2021. It's way too late to get paid for treatment in 2021. Your deadline for being paid for treatment is, it's either 90 days or 120 days, and the last day of the month that was incurred in. So we are going to look that up for you. We should be able to get you that. So hang on a moment for that one.
Is the filing date the date that the document was received in CIS? And if not, where would that information be found?
Okay, we've been speaking about a filing date. A filing date is going to pertain to a decision. So you have either a board panel decision, full board decision, or judge's decision. Those are the only times there's a filing date. Now, the filing date is going to be specified on the decision. Okay, so just look in the lower right-hand corner. It's going to be there. Now, if you're talking about filing dates about when documents are received in CIS, okay, that might be of some importance in some circumstance. CIS will tell you very clearly filing date, and then it'll also tell you very clearly viewable date. It's going to be specified right there in CIS. We're getting way down in the weeds here, but that's what we're here to do. When something comes into CIS, that's the claim info system that we use, it's going to be received, and then it might take a day or two or longer to actually be viewable. That's the viewable date. Okay, so the viewable date's not really going to be of such legal importance. It's the filing date, and that will be visible in CIS for everyone to see. And then there's the other matter of the filing date on a decision.
All right, we have a question here. Their PT is providing C41.Bs, and they received a notice of proposed conciliation decision directing the insurer to pay all medical bills related to the claim. No objection was filed by the final decision date by insurer.
Okay, this is a question that has to do with the process we use when an insurer disputes paying a medical bill. They're going to file a form called the C8.1B. So let's say you get access to your claim folder and you see all these documents in there, C8.1B. That's the insurer disputing some element of a bill, some element, okay? It could just be they don't want to pay for one of 10 services, or they think 2 services should be combined, or they could be filing it because the provider billed $100 and the fee schedule is $60. Okay, so right now I'm going to pause for a minute and speak to our friends in the payer community. If the provider bills $100 and the fee schedule is $60 and you pay $60, please, I'm saying please, do not file a C8.1B noting this. Do not. We have made this announcement before. Sometimes payers keep doing this. Please stop. You don't need to file an 8.1B that says you pay the fee schedule. No one's expecting you to pay anything else. But let's go back to the question. You're a worker, you're seeing these things. Okay, so they come in and the first review is going to go into our conciliation unit and they're going to propose a decision. Let's say, in this example, they propose that the insurer pay. They find on behalf of the payer. The provider, or the physical therapist in this case. Okay, if that never gets objected to, the insurance company needs to pay it. So if you're an insurer and you're hearing me, I'm sure you know you need to pay it. The insurers know these rules very well, and they usually do. So if they didn't, well, most probably it's an error. An adjuster just made an error, just missed it. You can certainly contact them. If it's an ongoing thing and you're not getting anywhere, tell us. We can contact the payer and remind them of this obligation to pay. From there, if there really is a dispute, then it's going to require the provider actually could file a judgment if they really wanted to go that far. But make the contact to the payer, just point it out. If you're not getting anywhere, ask us to help.
All right, folks, we got a few more questions that came in here. We're going to answer these before we sign off today. First question, if a case is controverted, is the employer obligated to allow the employee to charge their accruals?
Obligated? No, I don't believe that you are. You're outside of comp law at this point. You're probably inside of labor law. So I am not going to tell you to take what I'm telling you as definitive. You might want to double check that with labor, but you're now into the workplace and maybe not. I'm sorry, I can't give you like a really firm answer on that.
All right, if someone has been diagnosed with orthopedic injuries, PTSD, and hearing loss, all by specific board-certified doctors, how would that convert to the percentage loss?
Well, the question is going to be, are we at the point where the worker is as well as the worker is ever going to get? MMI, maximum medical improvement. If the answer is no, that means we're still in temporary world. Let's root for this person to heal as much as possible. Let's say that we're in permanent world now. Classification. So the worker is going to be classified either permanent partial or permanent total. Total is 100%. There is a formula, and I cannot walk you through that formula. You're indicating a worker who has some varied injuries, maybe of some complexity, maybe not. It's all going to come down to the medical formula and what the doctors say, the treating doctors, and what the IME says. The situation like this, there very possibly might be an IME. So it's going to be between what they say. Can't walk you through the formula, sorry.
All right, our last question. Our next question. If OTDA has requested copies of medical records from the board, is documentation automatically sent, or is that the responsibility of the worker or their attorney?
Okay, so you are speaking about something outside of the comp realm now. So the question itself is almost inherently contradictory. If they're requesting, then why is that the responsibility of the worker? They're requesting it. So whatever you have going on here, if it's not being resolved, you might want to contact our Office of General Counsel. If you have a legal question here, you can contact our Office of General Counsel directly, and they'll help you. They'll help you for sure.
All right, is there an easy way to determine LWEC percentage on the C4.3 rankings?
No. If you are an experienced attorney or a very experienced doctor, you might be able to ballpark it by looking at it, but If you're not, no. And you need to go through the formula anyway.
Last question of the day here, LMA related. If an injured worker gets a job while on partial disability, will that affect their ability to return to their prior job when they get down to 0% disability?
Maybe, maybe not. The answer, though, I'll bet you is unexpected. It's not, this is not a comp question. This is a workplace question. This is the relationship between the worker and the original employer. Does the original employer want the worker back? Does the worker want to go back to that original employer? So that's a completely workplace question. But as long as we're here, if the worker has a job and the worker's been on partial disability, well, partial disability benefit might end because the worker's working. Or this is where I should tell you about another benefit called reduced earnings. There is a benefit called the reduced earnings benefit. If you get a new job and you are earning less than your pre-injury wages, there's a benefit for that. So your average weekly wage was $1,000 before injury. Now you got injured, but you can work, but your average weekly wage is now $700 a week. That's a $300 difference, you see, between the $1,000 pre-injury and $700 now. The reduced earnings benefit will pay you 2/3 of that $300 difference, or $200. So you potentially could receive the reduced earnings benefit, and this is a benefit that does get awarded every day.
All right. Thank you, Joe. We are going to go ahead and wrap up. I want to thank you all for joining us. Thank you for your participation. It's been great questions today. We always appreciate it. Just want to remind you before you sign off, you can sign up to receive workers' compensation news, including information on future webinars, straight to your inbox. Just go to our website, wcb.ny.gov, scroll to the bottom of the homepage and select Get WCB Notifications. And again, we do distribute information on social media as well. So make sure you're following the board on Facebook, X, Instagram, YouTube. Again, I want to highlight that YouTube page, lots of good videos. We will be updating this recording and placing it on there. And again, we will email you when that is available. But again, we want to thank you all for joining us, and please enjoy the rest of your afternoon. Thank you.